And good afternoon, everyone. My name is Domenica Essie. I'm the CLE and Sections Manager here at the Cleveland Metropolitan Bar Association. Thank you for tuning in to today's program brought to you by the CMBA's Racial Equity and the Law groups, the real groups. If you're tuning in for CLE credit today, you have to do two things. Complete the poll that will appear on screen during the presentation and complete the survey that will be sent to you via email upon conclusion. If you have any questions throughout the program today, feel free to drop them into the Q&A at the bottom of your screen, as well as the chat, and the panelists will address those towards the end of the presentation today. So with that, I will turn it over to our program chairs, Edward Blakemore and Kelly Albin, for further introductions. Ed and Kelly, thank you so much.
Yeah, thanks so much. Thanks so much. Folks, I'm just going to give us kind of a quick overview and then we'll get right into brass tacks. Both Kelly and I lead a CMBA work group that's committed to communicating best practices for corporate counsel, looking to diversify their outside counsel spend, and assisting law firms in their efforts to recruit and retain diverse talent. So today's presentation will first focus on the recent Supreme Court affirmative action decision, so we can provide appropriate context on its actual impact. And so we've got a stellar expert who's going to speak to that issue. Next, after that, then we'll provide a summary of some best practices that our work group has developed over time. I find that CLE programs are most effective when you actually leave with practical and actionable steps that you can immediately implement, even if you don't have any headcount, even if you don't have any budget. And then finally, we've convened a group of local corporate counsel and outside counsel and law firms to discuss how they've worked on our work group, how they've developed best practices, how they've been able to implement meaningful change in their respective organizations. So that's kind of what we want to cover. So we've got a very robust agenda. And so I'll turn it over to Kelly to introduce our guest speaker.
Thank you very much, Ed. Our first speaker is Ishan Baba. Ishan is a partner at Jenner & Block and regarded as one of the nation's preeminent lawyers for institutions of higher education, as well as large corporations and organizations facing issues related to DEI initiatives. He specializes in commercial, constitutional, and regulatory law and has successfully litigated cases in numerous state and federal courts, including the U.S. Supreme Court. He has substantial arbitration experience, also represents clients before administrative agencies and government investigations. Ishan frequently advises public company boards on critical issues of ethical and regulatory risk, including most recently the risk companies face relating to DEI initiatives. He has been recognized by both Bloomberg Law and the National Law Journal as one of the 40 best lawyers under 40 in the United States. He's co-chair of the firm's education practice, DEI protection task force, technology practice, and a member of the firm's management committee. His DEI work has been featured in numerous publications, including as recently as the New York Times, an article a couple weeks ago, as well as the Wall Street Journal and Fortune. Ishan, thank you so much for joining us this morning, and feel free to take it away.
That's great. Thanks so much, Kelly and Ed, and it's a pleasure to be speaking with all of you virtually on these really important and critical topics. So what I'd like to do today in the 20 minutes or so assigned to me is basically three things. I want to, number one, go over at a high level a decision I'm sure we're all very familiar with, which is the SFFA decision out of the Supreme Court last year on June 29th, explain what the decision says and what it does not say. But given that I imagine very few of you listening in on this webinar work at institutions of higher education as a technical legal matter, the opinion actually has very little, if any, applicability to your day-to-day operations. Nonetheless, the opinion provides an important momentum and has provided an important momentum over the last 6 months as we look at attacks on DE&I in the corporate world and also at law firms. And so then I want to shift from talking about the opinion as a level of generality to the specifics of actual challenges that have been brought against corporate and law firm DE&I programs. What do they look like? How do these programs end up in court? And what are the results? And then number three, in whatever time I have left, I want to talk a little bit about the work that I'm doing and the kind of advice that I have been giving clients as they consider ways in which to keep their DE&I programs and commitments robust, but at the same time, critically, do so in a way that is risk adjusted to the organization's priorities. All right, so let's go ahead to the next slide, please. So SFFA, Students for Fair Admissions, obviously, as I'm sure all of you are well aware, is a case that was bubbling up for a number of years through two different courts. UNC was sued as a public institution and Harvard was sued as a private institution. I represented the Ivy League, or actually a group slightly bigger than just the Ivy League, as amicus in that case from the very inception. So I've been living with this case for many years. SFFA, founded by Edward Bloom, who is really in some respects the godfather, if you will, of the anti-DE&I movement, sought to require Harvard and UNC under, in the case of UNC, the Equal Protection Clause as a public institution, and in the case of Harvard, Title VI, which is a federal statute, part of the Civil Rights Act, that prohibits racial discrimination for recipients of federal funding, which Harvard is, like every single college and university in the country. SFFA sought to prohibit them doing admissions the way that had basically been done for 50 years. And that structure, as you may well be aware, under the Buckey decision, and more recently the Grutter and Gratz decisions, allowed institutions of higher education, as part of a holistic assessment of an applicant, to consider, as amongst many factors, the race of the applicant. And the reason the Supreme Court had allowed colleges and universities to do that was because it recognized that diversity of thought within an institution of higher education was a compelling interest, something that institutions could take steps to achieve, including race-based steps. Now, what was clear as before the decision came down on June 29th was that in conducting admissions, colleges and universities could not have quotas. Race could not be a sort of up-down factor, but it could be one among a number of factors. And so it was really that legal construct that SFFA attacked in its decision. It won in the Supreme Court. It had lost in the District Court and the Court of Appeals. We very much expected that. And then it lost in the Supreme Court, which frankly I also expected, unfortunately, even though I was representing colleges and universities that very much were defending the existing legal structure. What the Supreme Court said is important. In a decision authored by the Chief Justice, the Supreme Court 6-3 said that the use of race in college admissions violated the Equal Protection Clause and also Title VI because it did not satisfy strict scrutiny. Now, depending on what you do as a day-to-day in your work, you may be familiar with strict scrutiny, or it may take you way back to when you were in law school. But basically, strict scrutiny is the most forbidding standard of review in American jurisprudence. It requires that a party trying to justify its actions, in this case, the use of race, show a compelling interest as to why it needs to use race, and also that any actions taken in furtherance of that interest are narrowly tailored. This is the only thing that surprised me in the Supreme Court's decision. I was expecting the Supreme Court to say, look, all of the reasons that you give for using race in admissions, seeking a diverse group of students to foster diversity of thought, creating a pipeline for future leaders within your institution and society more broadly, having opposing viewpoints intersect with each other in exactly what you might imagine an academic institution to do. I was expecting the court to say, all of that is fine, it is compelling, but the means by which you are achieving those ends are not, in fact, legitimate. That is what I thought the court was going to say. But actually, the court went, I think, a good deal further. What the court said was, look, all of these things that you're citing as reasons, pipeline of future leaders, fostering diversity of thought, all the rest of it, are laudable, but they are way too indeterminate and way too hard to evaluate to merit any form of real judicial deference, and therefore we're not going to find them a compelling interest. Why is that important? I think it's important because when you think about the justifications for corporate DE&I programs or law firm DE&I programs, they're exactly the same thing. It's about a pipeline of future leaders. It's about the benefits that come from a diverse viewpoint on different issues, including diversity based on race and ethnic characteristics. And so the Supreme Court's skepticism about the principles underlying the college admissions programs, I think is really, really relevant. I'll just say, briefly to kind of finish this section about this decision, the Supreme Court's decision left very, very little room, as it says here on the slide, for the use of race in college admissions. I spent a lot of my time working with big companies and smaller companies as well, advising them on a whole host of litigation issues, including this. But the rest of my time I spent working with institutions of higher education. And one of the first questions I got from my clients was, look, all right, so diversity is out as a compelling interest, but there are other principles that one could use as well in order to use race in admissions, like, for example, the history of the association of slavery between a lot of elite institutions and slavery itself. If an institution itself owned slaves or sold slaves, is there some way in which we could use that past history as a justification, or maybe it's not even to slavery. Maybe it's simply that we have a past history of discrimination ourselves. Not we won't support, we didn't engage in slavery or support slavery, but we simply engaged in discrimination. Can we sort of ameliorate that past practice of race-based discrimination now through admissions priorities? And the Supreme Court obviously didn't address this issue specifically because it wasn't presented in the case, but in a number of footnotes and certainly in some of the comments made in the concurrence, it cast substantial doubt that it would accept these other rationales, given that it had rejected the diversity rationale. So that's really the kind of issue around race-based admissions. That's what the decision held. We can go to the next slide. I will just highlight for you kind of the key language. The whole decision is 270 pages. So as a public service, let me highlight for you, really what the key language in the decision is. One of the key languages in the decision is this first sentence. The Supreme Court and the Chief Justice in this opinion rejects the notion of using race qua race, race for race's sake. That's out. He says the whole point of the Equal Protection Clause is that the fact that someone's good at the violin or bad at the violin, and you might use that as a factor in deciding whether to let them into your school, is not the same as the fact that somebody is Hispanic or Asian or white or black. The Equal Protection Clause says that is just something that we consider in a different way. All right, the next slide, the Chief Justice then really talks about what I think is going to be the real font of litigation going forward, particularly for college and universities, but also for corporations and others, which is he says, look, you can't use race qua race, but you also don't need to take out the Sharpie and redact any information about race that appears in an application, because I can tell you, having worked with colleges and universities, there is a ton of information about race that they're still receiving. And so what he did, and you can go to the next slide, he sets up what is, I think, a subtle and difficult to administer, but critically important standard. What he says is you can consider race-based evidence when it goes to the individual student itself. And it talks about the way a student has attained what I would call a race-neutral priority for the institution, but you can't consider race qua race. So if you're looking at, for example, leadership, and a student says, look, I was the head of the Black Students Association at my high school. It was a huge high school. I was the head of an organization of, 70, 80 people dealing with all sorts of hot button issues. You can consider being the president of the BSA as a leadership characteristic, just like you would consider being the president of the student council a leadership characteristic. But what you can't do is say, oh, the student was the head of the BSA, he must be Black, therefore we're going to let him in to boost our number of Black students in our class. It's a difficult standard to apply. It's what's kept me super busy over the last 6-7 months. Very interesting, but not as directly relevant to, I think, your day-to-day business concerns. So I just give this as a little opening to kind of set the stage for the rest of what I want to talk about. But I think it's a critical point because a lot of when I'm defending cases, when I'm working with companies on these issues, it's all hearkening back to what the Chief Justice said in this opinion, because this opinion really does set the new baseline, the new floor for how courts are going to think about race-based distinctions within not only higher education, but also the workplace as well. All right, let's go to the next slide, please. So this is saying something to you I think you already know, which is that for lots of good reasons, DE&I is infused in myriad ways within corporate America. I've listed on this slide a number of ways in which companies and law firms have DE&I as part of their business operations, but I'm sure looking at this, you can probably think of examples within your own companies of lots of other ways as well. The point is just that DE&I is ubiquitous. It exists in a whole host of different areas, and it's something that companies have really leaned into hard over the last decade, and I would say in particular over the last 5 to 6 years. Now, that is wonderful because I think it's a value that many companies see as integral to their success and successful operations. It is also an area of real corporate risk. And I think that's the kind of whiplash, that's the pivot that we've been seeing and that's been keeping me very busy over the last year and a half, which is that companies that had basically leaned in very hard to DE&I and frankly had viewed the risk as not doing that enough are now seeing a backlash in some respects in litigation and in regulation, requiring some form of a recalibration, but also don't want to go too far the other way. So the question is sort of how do you hit that Goldilocks point where you are still maintaining fidelity to your DE&I commitment, but at the same time, you're not one of the low-hanging fruit that is likely to be the target of the next lawsuit or the next regulatory action or investigation. Let's go to the next slide. So what I want to talk about now and spend a little bit of time on is what does it actually look like when companies are sued over DE&I programs? There's a lot of noise in the news around DE&I, diversity being in the crosshairs, but what does it actually mean? And hopefully in going through this, it'll give you some indications as you think about your own companies or your own firms, do we have programs like this that could create vulnerability? Now, let me just say at the outset, and we're all lawyers, so I assume this is completely obvious. Obviously, the devil is really in the details. And while I would love to be all of your lawyers, I'm not. So, take this as a general guidance as to generally where things are. I will say that every time I do one of these projects, one of these assessments or audits, we discover new things, new ways in which, frankly, things fall between the cracks. And there's a lot of judgment calls in this area about how something is properly risk adjusted or not. But let me, kind of go through here at a high level 4 categories of litigation that clearly are active right now in this space. So number 1 is what I call DEI in business operations. And by this, I mean to capture basically everything that is a non-employment version of DE&I. So what does that look like? Well, I think at the very outset, Ed mentioned a good example, which is things like vendor spend requirements. When a company will say, listen, we want to try and direct some of our own internal spend towards companies or vendors that are minority owned. That's an example. Similarly, frankly, law firm guidance, where a company says, we want to know your commitment to diversity, law firm. How are you staffing your matters? How do your origination credits work? That's the kind of thing that I would put in this DEI, business operations. Another example is when companies engage in certain sort of business practices where they're trying to promote others using their platform. So for example, Amazon had a Black Business Accelerator program where basically Black vendors or Black-owned vendors on Amazon could learn how to be more successful in having their products, show up among the millions of products when you search for something on Amazon, how to be more successful, and you could designate yourself as a Black-owned business. Amazon was sued by a white-owned seller of collectibles, claiming that he was disadvantaged on the program in violation of Section 1981, which I'll come back to in 1 second, because he was not able to avail himself of all of these benefits that Black-owned sellers of collectibles could get on Amazon. Now, Section 1981 has really become one of these sort of statutes in vogue in this area. It's an old 19th century civil rights era statute that by its terms, it's written in a kind of a strange way if you'll Google it, but by its terms prohibits racial discrimination in contracting. Now, that is obviously a hugely broad category of things, and it's frankly a very under-litigated statute. But as a result, it's really been seized upon by opponents of DE&I programs in order to try and really have a statute whereby they can bring in a whole host of different non-employment things. So that's an example. There are lots of others, but time is short, so let's just leave that category as it is. The second category is employment. This is going to be familiar to lots of you. Obviously, Title VII is not only used for traditional discrimination, but also for reverse discrimination as well. What I think is interesting and the evolution that we have seen and we've litigated with our clients in this area is in a traditional Title VII lawsuit, when you want to show discriminatory intent as a plaintiff, what you'll generally do is point to a racist statement by a supervisor or some sort of an email or something that was posted on a company bulletin board to say, look, the adverse employment action that I faced was done in a racist way. Here's the email that shows it, or in a sexist way, here's the email that shows it. What we are seeing now, and frankly, what is really playing for some juries in these Title VII cases, is an invocation of the company's DE&I profile writ large. Plaintiffs will say, look, this company has so many DE&I initiatives, it really suffuses the company with this anti-white, anti-male, whatever it is, intent. And so my adverse employment action, you can assume was done with a racist intent or with a sexist intent, because look, the company's telling you what it really cares about is promoting people of color or promoting women and the like. And those arguments are actually quite, juries are quite sympathetic to those arguments in some cases. And there's a number of cases where we've seen juries really agree. There's a case called Novant Health, where in fact a jury awarded $10 million. It was reduced because of the Title VII statutory cap, but the jury would have awarded $10 million to the plaintiff making exactly that kind of an argument. All right, 2 more categories quickly. Shareholder lawsuits. So obviously, one of the things public companies care an enormous amount is what their shareholders think and what their shareholders are saying. And we're seeing a lot of different action in this area. For one, we're seeing a lot of shareholder proposals, and some of you may have experienced this as well, where basically a company will get shareholder proposals on exactly the same issue from diametrically opposed positions. And DE&I sort of writ large as an issue is a very popular one for this because it's easy to have a big splashy press release over. Sometimes the SEC will grant no action relief, but often it doesn't. And when it doesn't, companies have to then go ahead, put the shareholder proposal to a vote, and may have to act in compliance with it. So that's a real pain point. The other pain point we're seeing are shareholders who are really advocacy groups buying a small number of shares in a company, suing either as a books and records request or suing claiming that the company has breached its fiduciary duties by engaging in dialogue or advocacy on hot button issues, which has harmed the market cap of the company. So companies like Disney and Starbucks have faced those lawsuits. They've actually been very successful in defeating them to date, but we're going to see more and more of those. That's something I, help companies with a lot, is looking at their annual statements and the like to figure out what they're saying about DE&I issues, because oftentimes that's where these lawsuits really get started. And finally, this is less around companies being sued, but more around the overall environment. A number of states and exchanges, including NASDAQ, have tried to put into place requirements that companies have a diverse board representation, or at least explain why the board is less diverse than the state would like. Those have been challenged also by Edward Bloom-based organizations. And, there are some interesting sort of results there going both ways. And so I think the board diversity, again, in 20 minutes, I could talk about this stuff for 2 hours, but in 20 minutes, I don't want to go into too much detail. Suffice it to say, if your company has a board diversity requirement, or that's something you care about, that's something you should be looking at. All right. In the interest of time, I'll only say that there was always this sort of parasitic relationship between litigation and regulatory action. And everything that I've talked about as a matter of litigation, you also see in state attorney general enforcement priorities. And certainly we have dealt with subpoenas, we've dealt with investigations from state AGs on a whole host of different issues, but also certainly on the DE&I issues. All right, can we go to the next slide, please? So let's actually keep going. And let's talk here. So what do you do? Well, in 3 minutes, I'm not going to be able to give you my full set of advice, but let me give you a little taste of it. So look, I think there are a couple of different things companies need to do as they think about how to react to what is, without question, a more risky and a dynamic legal environment. One is really legal housekeeping. We can go to the next slide. So what do I mean by this? Fundamentally, I think companies need to view DE&I as a risk area, like you would antitrust considerations, like you would dealing with a regulator, like you would class actions, like you would a whole host of other things. So what that means is that as you think about what DE&I you're engaged in, do you have the attorneys at the company knowledgeable of it? Do you know what your full DE&I portfolio looks like? Do you know what you're saying publicly? Do you know what you're doing internally? Do you have a real list? Have you triaged all the different things that you're doing to make sure that the right hand knows what the left hand is doing? What documents are being created as people talk about new DE&I initiatives, as you're thinking about hiring priorities? Who is in the room? What kind of documents are being created as quarterly goals are set and the like? These are sensitive documents. The other side, which I litigate against frequently, is smart and effective. They know where to go to find, the smoking guns. Are you thinking about that? Also, you've got to stay informed. This is a dynamic area. For a lot of our clients, we do sort of a monitoring function where we help them stay abreast of litigation, state attorney general enforcement priorities. And whether you do that externally or you do it internally, in order to neither overreact nor underreact, you need to know what the current state of play is. And it's moving. And it's not just like looking at the Federal Register and seeing what your main regulator is saying. There are so many ways in which DE&I enforcement and litigation is happening. You have to stay abreast of it. All right, if we can go to the next slide. And actually, let's just in the interest of time, go forward again. And one more after this. All right, so let me talk about this slide for a second. So the other thing that we do when we assess companies' DE&I programs or audit them and help them think through, are you in a good place, is we really try with companies to go through and say, look, what are you saying externally? And what is the design of your program internally? And then this is a crude graph, but I was a consultant before I went to law school, so forgive me for, of course, putting up a 2x2. Think about what kind of risk does your company present in this kind of a way. So if you look at the x-axis, it's eligibility for benefits. So if you imagine on the left, it's a broad accessibility. Anyone can access whatever benefit we're talking about at the program. On the right is narrow, maybe just certain racial groups or certain genders or the like. And then on the y-axis, how big is the benefit? Is it small, or what in legal terms we would say, somebody really wouldn't have standing to challenge because it's a de minimis benefit. They're not really being denied anything. Or is it really big? Is it a kind of a program that somebody is going to feel really aggrieved and frankly want to go into court on if they're denied? So what we do is we'll look at companies' programs or law firms' programs in this kind of a way, and we'll sort of graph them. And what I would say is when you look at the top right-hand corner, those are your programs that are the highest risk, your big benefit, narrow eligibility programs. Now, look, That's not to say you cancel those programs, not at all. But number one, risk awareness is very important. So you know, okay, these are the programs that could actually get some scrutiny. And then, we do an analysis and say, okay, is this a program we really care about? Is this a program that we are getting our bang for the buck, i.e. it is achieving the DE&I priorities that we as a company have? If so, are there ways to risk adjust this program? Are there ways to make this program equally efficacious but less risky? So let me end with just one example of what that actually looks like in practice, then I'll pass it on to the rest of my panelists. So Pfizer was an early company who was sued for a DE&I program. It was sued for something called the Breakthrough Fellowship Program, where it took rising college seniors who were either Hispanic or Black, gave them an internship at Pfizer, and then basically a position at Pfizer and helped them move forward through Pfizer. And if they couldn't have a successful career there, they tried to get them a successful, those applicants, those people in the program, a successful career at a different company. So they were sued by an Edward Bloom-based organization saying, look, we have some white rising college seniors who are equally qualified, but for their race, and they should be given these great benefits that Pfizer you're giving other folks. That case is actually continuing to be in litigation over interesting issues of standing. Super interesting, but I won't bore you because I don't think that's actually relevant here. What is relevant is that midway through the litigation, without much fanfare, without a big press conference, Pfizer changed the eligibility criteria for the program. It changed it from being limited to Black and Hispanic applicants to those with a demonstrated commitment to Black and Hispanic advancement. Now, you might say that's the kind of change that only a lawyer could love, even though, given that we're all lawyers, I guess we should all love it. But the point is, it's those kind of careful in the details changes. If you think about doing them proactively, as opposed to once you have been sued, it puts you in so much better position to both be creative, reduce the risk to the company, and also allow you to keep achieving your DE&I priorities. So I think I may have gone slightly over my time, so let me be quiet now, and it's been a pleasure talking to all of you.
Well, thanks so much, Ishan. Really appreciate the overview that you provided, and certainly I know there are a couple people with hands up. We'll take some questions at the end just because we're trying to kind of make sure we maximize our time and get through our material. So I'm just going to briefly go through just some best practices. Starting off just here is that this is kind of a graph that will show you where your program may be. And we're not casting any aspersions on anybody as to where their DE&I programs may be, but this is, I think, a nice graph that takes you from the beginning all the way up to advancing. And those key elements that you'll find at the bottom there in terms of the actual tracking, tracking of that diversity spend, doing some type of review of kind of how things have panned out with your policies, and then as well being intentional, I think have been found to be those top three things that you find with companies with the most substantial DEI programs. And next slide. And then I'm just going to highlight a few of the things that we've communicated to others as a part of our work group that you can do. And again, these are things because, believe me, as corporate counsel, when I went in-house, I had no idea that I was going to actually lose resources. And so I was going to actually go from having more resources when I was outside counsel to less. And so you might say, well, Ed, yeah, my general counsel's got this new requirement. We're trying to work through it, but they didn't give me any people. They didn't give me any budget. How am I going to actually have any impactful change? And so one of the ways you can do that is typically from a corporate counsel perspective, you have some type of a matter management system that says we have this many IP cases, this many product liability cases, whatever. You utilize that matter management system to kind of drill down on your top 10 to 15 law firms, assuming that you've got some demographic data about the people who are working in those firms. You run that report, and then you're in a much better position to understand trends and understand where you sit from a DEI perspective on the diversity of your outside counsel spend. If in fact somehow you're not using a matter management platform at all in-house, then one of the other practices is you can ask the law firms, you undoubtedly can still run a report to know top spend law firms. You send an email to whoever your managing partner is of your relationship, and you ask for a 2 to 3 year regression analysis. I'll leave it to you whether it's by practice area or for the whole firm, and ask them to populate it with things like gender, race, and just spend broken down by those categories on either individual matters or total aggregate spend of your that you've had with that firm. That will tell you a lot. Because almost every law firm today has someone whose exclusive job is to be billing coordinator and to run those kind of requests. So it's not as though that's a unique thing that you're asking for. People ask for it all the time. And then so once you've run that report, now you've got to analyze that report and kind of see maybe everything is great. One of our colleagues on our report noted that when she ran it, she found that the women that were getting work on her matters was stellar. She also found she had some areas of improvement for some of the minorities doing work on her matters. And so this is like accountability. I often say, people will often say, hey, yeah, I promise I want to, I haven't eaten anything but grapefruit for 2 weeks and somehow I gained 15 pounds. This is an accountability measure that keeps you from kind of engaging in that kind of thought process. And you identify your gaps and then you create, just like any other business goal, kind of your strategic plan. Next slide. And then as well, obviously, our work group meets on a quarterly basis. We can be a sounding board because we bring together quite a few folks who are working as corporate counsel, quite a few folks that are working in law firms and other organizations. And we share best practices. We usually have a pretty aggressive agenda, and it's a good way just to balance yourself. And so that's another way to get some of that information and intel from companies or organizations just like your own. And then the people who are doing the good work, if you've got firms or vendors that are doing great work, please do congratulate them. Please do recognize them. The other piece there, when you're talking about if you're not getting the diverse spend that you'd like, then one great tip is just partnering with those firms on their respective initiatives. And so whether that's maybe a secondment, whether that's where you might share a 1 or 2L or 3L law student, there are a lot of different ways to formulate that. But I find those partnerships then yield great results because you've got that person who's working in your law office. They have a relationship with one of your key clients. It incentivizes you to, if that ends up being a good match, incentivizes the firm to bring the person on and make them an offer. It incentivizes that person to then have some ability to market and deal with clients on a direct basis at a very early stage. And then as well, you just from an accountability perspective, want to set the expectation that you're going to request that report or run that report, depending upon your preference, and that'll be reviewed. At Rockwell, we send out an evaluation at the conclusion of a matter that includes evaluating firms on exactly those characteristics and many other things. And then next slide. And then just a few other tips, and then I'll turn it over here, is that certainly if you haven't in a while, update your outside counsel billing guidelines to reinforce the things that are important to you. And so you'll be surprised sometimes a corporate law department hasn't looked at those outside counsel guidelines in 3 or 5 or 7 years. And so it's a great opportunity to also amplify kind of what your expectations are and provide clarity to your outside counsel. And then as well, the couple other tips are just being intentional. So when frequently folks will tell me, hey, well, Ed, we've only used this firm. This is the firm we go to for this. I tell folks, just check the firm's website. And I guarantee you, if you go to the firm and say, hey, I've got this new product liability matter, can you do a conflicts check? I'd like to, here's the team I'd like to staff. That seems like they're in the right practice group and everything. There are very few instances where a firm will disagree with you. And now you self-diversified the team who's doing your work very easily and without a lot of fanfare. You don't have to check a bill because you know who's actually doing the work. And again, firms will generally agree with your recommendation because they're the lawyers that they've chosen to hire. And then as well, when you're thinking about also on the back end, when you get your invoices, pay attention to who's actually doing the work. And if in fact the people who came to you to pitch and say all the great things they could do for you aren't and that very diverse group is not the same people actually submitting a bill, then that's a point of conversation as you're managing that relationship. And then one final, here's our first poll. And then just one more slide here, Kelly. And then, like I said, I talked about the outside counsel evaluation form that you can create if you don't already have one. You should be giving your lawyers regularized feedback about all the work they're doing. So if they're not making budget or they're over, whatever the criteria are that are important to you, we've socialized the form that I use and others use. But the key thing is that you have the things that you care about are encompassed on the form that you use to evaluate, and that you have that cycle of continued discussion so that you can get the best services, and the lawyers can, because lawyers love to get feedback, contrary to some people's popular belief. And so you give that feedback, and then you're in a better position to get the services that you're looking for. And then I'd say the last piece is that, sometimes you have to be open to leveraging new lawyers or different lawyers. Be surprised about how sometimes you get very complacent in the services you've always gotten because somebody shook somebody's hand in 1978 doesn't mean that has to be the firm that is the only firm that could ever do the work. So that's all I wanted to share. I'm going to hand it over to Kelly to talk about some best practices around both the recruitment and retention of diverse talent.
Thank you very much, Ed. And to piggyback off of Ed's presentation, I hope it came through that a lot of what we talk about within our real working group and a lot of what is presented here is just like as in-house counsel, we expect our law firm folks that are supporting us to be our partners. We really stress that, it's about setting expectations up front, continuing the conversation and trying to serve as partners to help them. Because recognizing that it can be tough and, resources can be stretched thin, all of that. But if you don't talk about it, you don't set the expectation and have that conversation, then you're not going to make progress on that front. So getting into recruiting and retaining diverse talent, I'll move through these pretty quickly. So when thinking about recruitment and retention, the best starting point is just assessing where you're at and determining where you would like to be with respect to DEI. So first assessing what is the diversity of your teams, whether that's running a formal report through your system, depending on how large your team is, looking at new and backfill attorney roles, as well as regrettable losses within the department, looking for trends, potential opportunities. One good thing to do is setting an expectation at the leadership level, either making this part of a leadership scorecard or scheduling regular touch points to monitor progress on DEI initiatives within your law firm or your organization legal department. Seeking and evaluating feedback from regrettable losses, as well as conducting stay interviews with diverse talent. Identifying opportunities to develop diverse talent in addition to what you're looking at from a broader succession planning standpoint. And when you're looking at evaluating those retention and development opportunities and strategies, really thinking about how and what work is assigned, mentoring and sponsorship opportunities, leadership and development, compensation and promotional practices. And then specific to law firms, we've talked about on this a bit, origination credit policies and the like. And then really setting an expectation that this is something that internally you'll be looking at on an annual basis, at least an annual basis, to gauge where you are. From a recruitment standpoint, assembling diverse candidate pools for all positions and promotions, both at the more senior leadership level and entry-level positions. Scrutinizing your hiring criteria and the language used and job postings to ensure that you're not unnecessarily excluding qualified candidates. Distributing job postings through groups like our Real Working Group, affinity and diversity focused bar associations, and then also requiring your search firms and recruiting teams, setting an expectation with them that you do want and requiring a diverse pool of candidates for open positions. And then leveraging diverse teams to interview candidates for open roles. Consider applying for Mansfield certification. Both that applies to the law firm context as well as the legal department context. Now there's two different types of certification. And then also considering your just general disclosures, whether you're within a company and you're talking about DEI initiatives, you can do the review from a risk standpoint as far as the anti-DEI front, but then also taking a look at your disclosures and are there microaggressions or anything else in your disclosures that maybe are going to turn somebody off to your organization when the intent is there to be making progress on these fronts. And then finally, active engagement, not necessarily just when you have a position open, but then just regularly engaging with different networks, affinity bar associations, work groups like the one that we spearhead and some of the other work groups and initiatives at the CMBA under their Racial Equity in the Law initiative. And when I say, not just waiting until a position is open, joining those groups so that when you can start to connect with other like-minded folks who care about these topics, and you can potentially tap into their networks and share your positions when it becomes available. And then also the CMBA, and there's lots of other resources that have additional best practices on this front. So with that, I would like to turn to our panelists for their perspectives on some of the topics presented today. And so Ishan, we haven't identified you as specifically part of this panel, but you're definitely part of, as we were asking questions of our panelists, feel free to chime in and be sharing your thoughts as well. I'm so impressed with all of the content that you covered in a very short period of time. But please know that you're welcome to chime in and answer some of the questions as well. But so we have with us Kelly Barnett, who is Senior Vice President, Managing Counsel, AmTrust Financial, Manju Gupta, who's counsel with Tucker Ellis, Drew Odom, who's Senior Legal Counsel at Goodyear, and Natalia Steele, a partner at Voorhees. All of our panelists are very active members of our CMBA Real Working Group. They have been actively engaged in discussing DEI topics and sharing best practices, and serve as advocates and leaders within their respective organizations, communities, networks on a variety of these issues. So Ed, you want to go ahead and start the panel discussion?
Sure. And I'll start off with just how has the new decision impacted your respective DEI strategies? And maybe I'll start with Kelly Barnett here, and anyone else who wants to comment on that.
Ed, you're picking on me already. No, thank you. And thank you for including me in today's discussion. So with respect to how it's impacted my DEI strategies, my expectations of my outside counsel have not changed, but what I have viewed this as an opportunity is for me to sort of sit back and take stock and assess my approach to make sure that it's not only compliant, but also is it working? Is it thoughtful? And so I have viewed this decision from SCOTUS as an opportunity to do that. And I've spent a lot of time looking at what I've been doing and what I'm doing going forward. And while I don't think that the SCOTUS decision should stop companies and law firms from engaging in their DEI efforts, I think that would be a terrible outcome. I do think that this and some of the reactions that we're already seeing that Ishan described, I do think it should serve as an important reminder that our strategy should really be focused on, and this is really what I think we need to emphasize, really be focused on removing barriers and bias to the exclusion of no one. Okay, and so that is what I really tried to focus on in the last several months. I've looked at my messaging. Okay, we do have a due diligence questionnaire that we send to our outside counsel. It covers not only diversity topics, but everything, cybersecurity protections, malpractice issues, everything that we would like to know from our outside counsel. But I've looked at the messaging there, and I've looked at the messaging in our outside billing guidelines, our diversity statement, and our billing guidelines. I've also looked in other places where we've messaged to law firms about, me specifically at least, where I've messaged my expectations to them. And then I've looked at, how am I actually operationalizing all of that? Okay, so here's what my messaging says, but how am I actually putting it into practice? And, I'm trying to make sure that I'm very broadly defining diversity. It should not just refer to race. It can include a wide variety of things beyond just the sort of protected classes that the employment lawyers who are listening are probably thinking of. I think it could be as broad as things such as, socioeconomic backgrounds, geography. I mean, diversity should be broad, in my opinion. And so that is, again, it has not changed my strategy, and it has not changed my expectations. But what I would recommend to any of the in-house counsel listening is that sit back and take a look at what you're saying and what you're doing, and making sure it's compliant and making sure it's effective.
Anyone else want to comment on that topic?
Yeah, I can jump in. So as a firm, we also, in wake of those decisions, created a working group that went over what is it we're doing, what is it we're saying. I think this decision for us, as Kelly just mentioned, didn't change anything, but made us really look deep into what is it we're doing, what is it we're saying, do those things match up, and is what we're doing effective? Is it producing the results we're looking for? And on the flip side, in the relationship with our clients, it made us even more aware of outside counsel guidelines and sparked additional conversations with our clients where the guidelines are potentially pushing the envelope a bit in the wake of those decisions and are actually requiring reporting and metrics and measurements that can potentially not necessarily get us in trouble, but get our clients in trouble. So it sparked a lot of conversations about what is it that you're asking us to report on and what are the goals, and got us into actually a lot more interesting conversations with our clients about their expectations, how we can help them. How can we work better together for everybody to be well protected, but also achieve the common goals that we have through these communications. And one of the things that we're really closely looking at in outside counsel requirements or these questionnaires that we're receiving are any kind of individual attorney metrics. We typically don't report them for a variety of reasons that preceded these decisions, but for any in-house lawyers that are on the call, I would challenge you to really think about requiring your firms to report any individual team member level diversity statistics, because for us, they're self-reported, and we will typically report on constitution of teams, but a lot of times we will decline to report on individual level metrics because they are protected in a variety of ways, including potentially creating an issue under this new kind of decision that everybody's trying to understand how it applies. But those are the kinds of things that have been going on for us.
And then and I think maybe I'll start off with Drew or Manju here, but can anyone share some unique partnerships they've had with between their companies and or law firms that have advanced kind of the overall diversity of legal professionals representing your interests? And so, Drew, why don't you kind of start off, and then maybe we'll give it to Manju to amplify.
Yeah, I mean, thanks for the opportunity. I have to say just up front, I can't speak for Goodyear. I'm not authorized to speak on behalf of Goodyear as an organization, but I can talk about, my personal experiences. Our general counsel, he wanted us to be Mansfield certified. And as part of that effort, we needed to increase the number of outside firms that were just pulling from a more diverse group of talent. We wanted our either firms we're working with to diversify the teams, or we wanted to start looking at new firms. And I think at first we weren't really doing so well. And me personally, I just wasn't sure what I could do to help, because at least at the time, I didn't personally hire a lot of outside counsel. That just wasn't part of my job duties. But I did start some conversations with the folks at Goodyear that are more actively hiring outside counsel. And what I learned is that, they're all on board, and they want to, help us diversify our talents. I think we all agree we get better results when we have a more diverse team. But they just didn't have like a ready to go bench of talent. It was kind of like, hey, something happened. I got to hire somebody really quick. I don't know who. Who do we use last time? Who did the guy in my job, a decade ago hire for the same thing? and you just hire the same people over and over and over again, whether or not you got good results. It was just kind of like, hey, I got to put out a fire. And that was kind of the attitude. So I said, what can I do to help? And what I ended up doing was coming up with this program we called Considering Outside Counsel. And I think a lot of there's definitely got to be some people on the call now who have been part of this program. But we just decided to invite or ask the firms we're working with and invite new firms to come and present every month. And around lunchtime, we got all the attorneys and at Goodyear together, and just had an hour-long call where the outside firms were able to pitch, have their diverse talent come and pitch Goodyear business. It's like there were firms that we've been using for a very long time that are pretty big firms who have been using the same lawyers. And it said, you go to the firm and say, hey, do you have anybody else? And you don't necessarily need them to fight over the same work. It's like, hey, we have lots of legal matters. Do you do anything else? Do you have any, some folks from different backgrounds who may want to present and pitch to us? So we did that every single month. We had, firms just come and pitch. And to me, that was an easy thing that I could do. I just set up the meetings. They were all virtual. It's pretty hard getting us all together in a room nowadays. So it's just setting up a nice little virtual meeting. We all sat, the firms were able to pitch their business, and it allowed, my colleagues at Goodyear to just have more talent to choose from. So it was a win-win for everybody. And then eventually I started encouraging the outside firms to start inviting some of their younger talent. I know when I was at a firm, I'd never got an opportunity to pitch or go along to these pitch sessions. So I said, hey, you got some first, second, third years who don't know anything about what's going on here. We want them to be able to pitch their business. We want to start this pipeline. So invite them so they can at least see what's going on or have some sort of just say hello type of thing. So all in all, I think it's been a relatively successful program. At this stage, we're kind of going back and just taking a step back and assessing. So those of you on the call who have been a part of the program, I will be reaching out to you fairly soon. Right now, we're looking internally and trying to see what we did well, what we can improve on, how we can make some changes. But to me, it was a low energy, easy way to just expose everybody on our team to diverse talent that we have in the legal market. Really easy.
Would you like to add anything, Manju?
So yeah, I can add some. So we at Tucker Ellis, we have gone to some of our clients and to some prospective clients. Right, we're Mansfield Plus certified. So that means in addition to just considering a diverse pool of candidates, we actually have a diverse pool of candidates. Frankly, that's one of the reasons I chose to move to Tucker Ellis is because it's a diverse firm. And typically, most of our clients are sending us surveys on diversity, equity, and inclusion. And it's a newer firm, right? So it's a firm that has kind of taken some of the stuff that hasn't worked in the past. And we pride ourselves on being different. And that does, in my opinion, really, it includes being inclusive. And even when we're not pitching, our teams are generally, they're just diverse teams because that's the pool of attorneys we have. And I'll just say, just emphasizing from my own experience of practice, right? It starts with, giving people the right opportunities and giving them training. And there's so many firms that I've seen that, they hire the diverse applicants or, minorities or women or whatever, but then they don't actually provide the right training. They're those women or minorities or they're not put on the right cases, right? So then eventually you get 10 years into practice and, those people don't actually have the right experience because they haven't been put on the right matters. So.
Well, thanks, Manju. I certainly have a couple other questions I would typically ask, but I think we'll we'll probably open it up to some questions. I know we've got another 10 or 15 minutes here, and I know we had some folks who already put their hands up and everything. So I think we've got a few questions here. One is many bar associations sponsor pipeline programs to give BIPOC law students access to internships and externships. Have any of these programs been challenged by outside groups or individual litigants? I think that's probably for you, Ishan.
Sure. So the answer to that question is, as of yet, not. I kind of think that these are likely to be the next font of challenges, the whole pipeline program like concept, because ultimately, you know, when you have a direct hiring program and you say, look, we want to hire, you know, 30% X or 40% Y, that's a very easy Title VII claim. That's a very easy, if it's not in an employment context, an easy Section 1981 claim. Pipeline programs are more difficult because it's a little bit more akin to the Rooney Rule, where you're basically putting people in the position to get a job rather than actually giving them the job based on that criteria. And so it's a lot more work for a plaintiff to challenge those kind of, you know, disparate impact like claims as opposed to the disparate treatment when you have a, you know, facially preferential policy. So no, I don't think there have been litigation over that yet, but I would imagine we'll see those things coming. All the more so, I would say, when you are tying either bar associations or frankly big companies, which would be, you know, good targets for these groups, when they have those sorts of pipeline programs or connections, I think you'll see that as well.
Then as well, how should corporations look at diversifying outside counsel without the risk of litigation? So I think that's probably, so certainly, Ishan, you can start, but then I think some of our other panelists should chime in.
Sure. So I'm happy to take that as well. I mean, you know, I get asked this question quite often by my clients, and I will say, I mean, I think for corporate clients, it's not your problem, it's the law firm's problem. And so, you know, to echo what Kelly said, I mean, I think for clients or for corporations to continue to have this as a priority is the right thing to do. And I think it's really up to the client, I mean, the law firm, as to how they implement it. What I would say is, you know, oftentimes you have to just take a step back and think, you know, what would the lawsuit look like here? From my perspective, the lawsuit in a case like this is not going to be, you know, a law firm suing a potential client claiming that they were not hired for DE&I. I mean, that would be business development suicide. What I think you're more likely to see is an associate or maybe even a partner at a law firm after they've been terminated by the firm, claiming in some employment discrimination suit that they were discriminated against at the firm because the firm is trying to cater to the client's, you know, preferences, including race-based or gender-based preferences of what case teams should look like, and they were denied, you know, adequate opportunities to be successful. Frankly, you know, I think that's an acceptable risk. I'm not the kind of lawyer who sort of runs away from any risk and says, oh, you should stop the program. You know, if an attorney is going to make that kind of a lawsuit, firstly, there's obviously huge personal cost to an attorney suing a law firm claiming they were fired for the wrong reason. That probably is going to have career issues. So already I think that's a barrier to those sorts of lawsuits coming. But number two, you know, the reason an attorney is separated from a law firm is multifaceted. It's highly subjective. It involves, you know, for most careful law firms, you know, substantial attempts to actually get the attorney back on track. And if it really doesn't work, it's all documented and the like. So I think that's the kind of suit most firms would be comfortable litigating and winning, knowing that the attorney was not discriminated against on the basis of race. And so given, I think, all of the positive externalities that come from clients continuing to tell law firms, listen, we care about diversity in all its manifestations in our relationship with you, I don't think that's a reason to stop them.
Do any of our panelists want to comment on that question at all? Then I'll ask one more question just for our panelists. Can you discuss any kind of unique obstacles that you've had to overcome or implement to improve any DEI practices, at whether that's at your corporation or at your law firm? And if you did encounter those, kind of how did you navigate those issues? And I'll start off with Kelly again. So we'll do a round robin here.
Yeah, I mean, I'm not sure it's unique, but I'll say a specific challenge that I faced since I've been in-house. You know, I mentioned earlier this due diligence questionnaire that we have, and I think we've talked about it in our rural work group meetings. And I've never had a firm decline to respond And we ask about all sorts of things. What are your DEI efforts? But also give us a breakdown of, your equity partnership, your non-equity partnership, things like that. But what I was finding is that, not surprisingly, firms are finding ways to answer the questions without actually answering the questions. And so, I initially jumped to conclusions, right, about why I was getting responses like that. But then as I sat back and I thought about how I would react if I was at a firm, I think that when you get those types of questionnaires from your clients or your potential clients, I think there's a reasonable fear, and they expect that if we don't like the responses, we are going to cut them off. We're going to stop giving them work. And that is actually not why I'm doing it. I think Kelly mentioned earlier that, at least speaking for myself, I view this as a partnership. We actually do want to partner with our law firms, okay? And we want to partner with them on these efforts, okay? And I mean it. It is not my intent to look at these responses and say, no more work for you. It's hard. It's hard to, put these sorts of programs into practice. And so that is really my goal. And so I think what it comes down to and what I learned from that experience is it's all about how you frame it. And so what I did in response to getting some of those interesting responses to our questionnaire is, I let them know, like, this is why I'm asking for this information. It's not to exclude you. It's not to deny you work. It's to look at what you're doing, how you're doing it, and whether it's working, and how we can facilitate, between the two of us, meaningful and productive discussions about how we can continue to impact in this space. And I found that when I did that and really just framed it as, this is just starting a conversation where we can help each other. I feel like once I started doing that, I started getting the meaningful feedback that I was looking for, because the questionnaires were kind of useless in the beginning because I hadn't had those conversations with the firms and I hadn't, framed it that way. So I think for any in-house counsel who are using questionnaires or asking for information, which I suspect many of you are, I think it's important to let your outside counsel know why you're doing it, okay? Because if you don't get the meaningful information, then there's no point in asking, in my opinion.
Does anyone else want to comment? Drew?
Yeah, one thing that I've kind of seen just generally is that maybe the biggest difficulty in all these efforts is just we're dealing with humans who prefer to be with people who are like themselves. So, most of the partners at law firms tend to be older white men. And when they realize that, oh, we got to diversify our team, they tend to try to find someone who is not a white man, but who thinks just like they do, because that's the person I can work with the best, which doesn't really serve my needs very, all that much. I had a case a couple years ago now where we ended up firing the first lawyers we worked with, but we got another set, and there was this Catholic Irish guy who, this was probably going to be his last case. He was going to be retiring. And then there was a younger Black guy who was a prosecutor beforehand, and he was from New York City. He just had a completely different experience. And these guys were opposites, but they worked very well together. And whenever there was an issue, I would say, what do you guys think? They would give me two completely different answers, but there were two good answers. And I had options and choices, and I just got way better results. And I was very, very happy with the legal services I received. And what I'm seeing with a lot of firms is that you say, hey, diversity and inclusion, DE&I, Mansfield certification, all this good stuff. And then you see their teams and they're kind of like, all right, let's go and get some Black associates. They get a bunch of them. And the ones who aren't just like them don't really go very far. They don't feel like they are valued. They don't feel like they are able to be their authentic selves, because that's not valued. We don't want to work with you because you're different. Oh, you're a weird guy. We don't want to work with you. Oh, you like that? Don't want to work with you. And then that person just is at the firm, no work. And then they end up either going somewhere else because they don't get any work, or they're just never developed, or they just don't get the skills they need because they've been at a firm for 3 years doing almost nothing, and they're behind their peers. So I guess human nature is a big issue. I think we have to be very conscious and aware of what our biases are, not just go to the trainings and then check a box, but actually think about it and listen. Look at people on your team who may think differently than you, not just look differently than you do, and then try to develop them. Go outside your comfort zone, go outside that box that you're used to, and develop those associates who not only look different, but are different from you. And you'll probably give your clients better results.
Really well said. Manju or Natalie, would you like to comment?
So yeah, just to add to that from a firm perspective, which I've only been at law firms and I haven't been in-house, but you know, one thing that I've seen in the past where you know, when teams, you know, for litigation are being created, that you have the token female or the, you know, young Black, you know, male associate on the case. And then what ends up happening as the case progresses is that person really gets, they're just the token. They're really not given the experience. I mean, that does not help anyone, right? In the long run, as Drew just said, you're just checking a box. Like, I mean, when you're, you know, providing, when you're creating teams, like really, I don't know, in my opinion, you know, pick people that can, yes, that diversifies your group, but actually, you know, you're going to provide the work too, and they're going to be an active part of the team. I mean, because I've just seen it happen so many times where, you know, a new associate who's the minority will be added to a team, and then, you know, they're really not getting any of that great experience that they should be getting. So that I'll add that to that conversation.
And to piggyback on that, I think it takes, and at least in my experiences, there's always been like just a handful of people who are just different, and they would reach out and work with this young associate who knows absolutely nothing and suffer through the frustration of dealing with this young attorney who's making all these mistakes. And when someone is very different from you, it's easy to be upset with that person and just dismiss them. But when they're similar to you, you're like, oh, let me take this young kid and work with this young lawyer and teach them how to do things. So you just have to overcome that bias that you have. And it's like, okay, this person is different. They're frustrating the hell out of me. But I'm going to work with them and bring them to where they need to be so that they're actually a good lawyer. Because you have to understand, I mean, I think we all know that these first, second, third years, they're not coming out of law school knowing how to practice law. You have to mentor them, you have to teach them, you have to give them the experiences, you have to work with them through all the mistakes too.
I'd like to build on that, and also something that Manju said about, you know, having the token female at the pitch, but not actually letting them do the work. And I think that is where I really think firms could drill down and be more inclusive. Okay. And that's what we're talking about here. And what I mean is giving them not just the work, but the visible work. Okay. So are they just doing the doc reviews, sitting behind you while you argue the motion? Are you letting them take the deposition? Are you letting them, you know, take a crack at arguing the motion? Are you letting them interact with the client? Are you bringing them to client meetings? Are you giving them or bringing them onto, you know, those class action matters, the complex litigation matters? I mean, those are really meaningful ways to be inclusive with the attorneys at your firm. So that is something that I really focus on when I'm looking at my numbers.
You know, a really obvious thing that I didn't think I had to say, but, you know, again, in my experience, when I reach out to a Black attorney and I say, hey, why don't you pitch your business? And then when they come to pitch, their managing partner does all the talking and won't let the person who I invited to come speak. It's not a good look. It doesn't look good at all. I'm not sure what's expected after that.
I want to add something from firm perspective for in-house counsel. Ed, you asked about unique challenges, and one of the unique challenges we had over the last couple of months is that we're going through rate increases. Everybody loves that time, I know. But what we find a lot of times is when rates are rejected, invariably, if we don't have a conversation with our clients about, I am trying to get this minority attorney in front of you, and I am trying to get them to be more recognized in the firm. If you continue to keep them down on their rate, they're not going to be internally in the firm potentially viewed as valuable. So when it comes to rate negotiations, I would encourage in-house counsel to really also pay attention to that piece of your diversity spend. If you continue to reject, attorney, I am pushing up the ladder and trying to get them into that, earner phase, right? Like somebody who's making money for the firm, and you continue to say, I cannot pay their rates, eventually internal structures in the firm are going to work against them. And so think about, as your diversity spend, also that piece of the puzzle. Because
Natalia,
that's been a unique challenge recently for us in the last couple of months, where we had to call our clients back and say, understand what you're doing, but these particular people need a little bit more of your help here.
Natalia, I think that's a great point, but I want to flip the script a little bit, because sometimes when I'll say to a firm, hey, rates are a little high, can we work together? And what they'll do, and I had this happen a few years ago, is they cut the rate of the diverse associate.
Yeah.
And I mean, I noticed it right away. And so, and I don't think it was intentional. They were doing what I asked, which was, can we give Kelly better rates? Kelly called. She doesn't like our rates. She's asked us to work on it. And so that they did what I asked, but they did it in a way.
By you noticing that is a great help to us, is to challenge your firms and to say, not here, maybe somewhere else, but let's not devalue this particular member of the team. Let's get the whole team to be more competitive.
So yeah, no. And so I thank you for bringing that up, because I think it's a good lesson, particularly for in-house counsel. Pay attention to the rates. Don't just look at the bill. Don't just look at the budget. Look at the rates and which ones are getting cut, and ask questions if you need to. I mean, I think we have a responsibility as in-house lawyers to ask some of those tough questions. And I would encourage you not to shy away from asking them.
Use your bully pulpit. The biggest change I have seen in our law firm and other firms came about 13, 14 years ago, when you started sending out those questionnaires and expectations for your team staffing.
Right. Well,
So much of what we've talked about is just being intentional, and exactly what Kelly was just talking about is looking at the rates, look at who's really doing the work from an in-house perspective. And then also, I hope that on this webinar, what we've highlighted for you is that regardless of what level you are at within your organization, there are still ways that you can be intentional and influence change and help emphasize the importance of these initiatives.
And so we're at time, and I really appreciate everyone's time. Certainly, if you have interest, as you see up on the slide, if you'd like to join our real work group, we're happy to accept additional folks. We're suckers for good conversation. Again, we're exchanging these best practices and helping people kind of navigate these waters. So we really, if you're interested, feel free to reach out to the Bar Association or Kelly or myself. And certainly, if there are any other questions, you certainly know how to reach us. We can follow up at a later time. And if you like this program or programs like it, please let the Bar Association know, so we can make sure that we're suiting your needs and helping you develop professionally. So with that, I really appreciate Ishan and our entire group of panelists, and certainly Kelly's partnership. And I think we're at time. And but again, we really appreciate everyone's time today, and hope it was informative.
Thank you so much, everyone.
Okay, have a good day now.
Thank you.